This case starts like many domestic violence cases, but quickly turns into something far more complicated. A criminal charge gets dismissed, fingerprints are ordered destroyed, DNA records are wiped, and yet one single phrase in a court document may still change a man's future forever. Imagine being told your case is dismissed, only to discover that a few words buried inside legal paperwork could affect your immigration status, citizenship application, and even your career. That's exactly what unfolds in this courtroom. At the center of this battle is a lawful permanent resident who says a dismissed case may still cost him his American dream. The prosecution insists they did nothing wrong. The defense argues a simple wording change could make all the difference. And the judge? He's caught between legal procedure and real-world consequences. Was this merely standard legal language, or a bureaucratic landmine with life-changing effects? Stay with us, because this hearing dives deep into how collateral consequences can follow someone long after a criminal case ends. And by the end, you'll have to decide, should courts prioritize technical legal accuracy, or should they prevent unintended harm when someone's future hangs in the balance?
All right, we're back. I've titled this matter Hearing on a Special Motion. The title of the case is People of the State of Michigan versus Ladislav Visky. File number is 26371SM. Mr. Visky is present here with his lawyer, Mr. Luke Nofsinger. Also present is Abby Stoll from the prosecuting attorney's office. The defendant was charged in an original complaint alleging domestic assault that allegedly occurred on May 10th of 2026. The complainant was at the Courage Hospital, and the investigation started from there. Sometime after that, the defendant was arrested for domestic violence. The matter was set for an arraignment, then it was set for a pretrial, and after some discussion, the prosecution filed an order of nolle pros. The actual Latin name is nolle proseque. I think it means no proceeding. Anyway, it's an order of dismissal. That was filed on March 26th by Gary Gabry, Chief Assistant at the Prosecutor's Office. It states, defendant has complied with all terms of the plea agreement. Prosecution moves to dismiss. So I signed it. I ordered the motion for nolle proseque is granted and the case is dismissed without prejudice. Bond is canceled and shall be returned to the defendant after costs are deducted. And the Michigan State Police and arresting agencies shall destroy the arrest records, biometric data, DNA profile as required by the statute. And that was indicated dated 26th of March. Mr. Vitsky came into the court a couple of times and in the middle of other hearings and inquired about this. And then ultimately advised him he was going to need to file a motion. He was not satisfied or content with the order and disagreed with the language. So Mr. Nofsinger has filed a motion to correct the nolle pros pursuant to 643(5)(a). And Ms. Stoll has filed a brief in opposition stating we meant what we said the first time. So Mr. Nofsinger, what would you like me to know?
Yes, thank you, Your Honor. I recognize this is a very unique request, and it is rare to see a nolle proseque before its entry by the court. We have a very simple request, Your Honor, is that the word plea be removed from, or amended to be removed from the nolle, because it will not only affect Mr. Vitsky's immigration status. He is a lawful permanent resident, a green card holder, and the crime that was charged would be considered a crime of moral turpitude under federal law. And I came on to the case actually after it was dismissed It's my understanding this was discussed to a certain extent. There was some hoops that
What makes this hearing so unusual is that the defendant isn't trying to overturn a conviction or reopen a case. He's asking the court to modify a single phrase in a dismissal order. In legal terms, that's incredibly rare. The defense argues that the words plea agreement could be interpreted by immigration authorities as evidence of wrongdoing, even though no guilty plea was ever entered. This is where criminal law and immigration law often collide in unexpected ways. A case dismissed in state court doesn't always disappear in the eyes of federal agencies. And that's what raises the stakes here. The courtroom may see this as routine paperwork, but federal immigration officials could see something entirely different. What do you think? Should courts revise language if it creates unintended consequences, or should official records remain exactly as originally written?
Hoops that Mr. Vitsky jumped through, he did in fact do that. And so for that reason, Judge, the plea will affect his immigration status because the USCIS, which would process that, not only his review the status of his green card status, but then also adjudicate an application for naturalization. He also is a federal contractor, and this is affecting his employment for that same reason. Mr. Vitsky is actually relocated to Arizona, and he flew in just for this hearing. It is very, very important for him, Your Honor. I think that after reviewing the language in the NOLI, that it is misleading to someone to read, to see that there was a plea agreement. Certainly, there was an agreement.
Well, all right. So what would you call it? Just an agreement?
Yeah, it was an agreement. No plea was entered. I don't think there's any.
Well, a plea of not guilty was entered.
Sure. In this context, it's misleading. He entered a plea of not guilty. Sure, if we want to say there was a plea of not guilty and then the case was dismissed. But in this particular context, it is misleading to read that he agreed to a plea. And so for that reason, Judge, and primarily, practically speaking, the USCIS, and this is where I get a little uncomfortable because
what is the USCIS?
Judge, that is the agency under the Homeland Security.
Well, I've had all these representations that has these ramifications, but I haven't seen anything. I don't know if you shared anything like that with the prosecutor.
Sure. I mean, one thing I was going to ask for, Your Honor, is if the court would be inclined to have an evidentiary hearing on this point. It's clear to me that conviction for domestic violence would be a crime of moral turpitude. That's federal law. I can brief the issue further.
No, but you indicated that he's confident that it's going to affect his immigration status. Mm-hmm. Do you have a letter? Is there anything to the effect that this is going to have a negative consequence, or it's just a concern that he has?
No, I believe he's on the impression that it will.
But impression how? Just what he believes, or there's something in writing someplace?
Yeah, would the court like to inquire, Mr. Vitsky?
The judge raises an important question here. Where's the proof? Courts operate on evidence, not assumptions. While the defense argues that immigration consequences are likely, judges often need documentation, letters, notices, or expert testimony to justify altering an official order. This moment highlights a frustrating reality for many immigrants. Government agencies don't always provide written guidance, leaving people caught in uncertainty. The defense says USCIS communicated these concerns verbally, but verbal statements are notoriously difficult to prove in court. That creates a legal dilemma. Should judges act proactively to avoid potential harm, or should they require hard evidence before changing a court record? It's a fascinating clash between practical reality and strict legal procedure, and the outcome could affect far more than this one defendant.
Mr. Vitsky, I think he's...
Yeah, Mr. Vitsky, as I indicated, you had stopped me here in the courtroom once or twice in the middle of or after other hearings, and I wasn't even really able to address it. But Who is telling you that this is going to affect your residency status?
Agency USCIS, United States Citizenship and Immigration Services. They do not provide letters. I have requested letters. They told me over the phone it is considered moral turpitude, bad character of moral turpitude, and my application will be denied based off of that, unless I have to wait 10 years to clear the record so I can reapply again. However, my current status is active for 2 years only. So it's either I have to finish my employment right now, I have to leave the country and maybe try 8 years later. But I have requested letters twice, and they told me they wouldn't be providing any letters.
Right, but someone from the federal government is representing to you that
yes.
This is
on top of that, for my employment, I have received temporary clearance based on pending case right now. And the clearance to work with federal government is going to be revoked if I cannot resolve this matter successfully.
Is the fact that you've married an American citizen a factor in attempting to get permanent residency status?
Yes.
All right, so I'll take it at your word. You're not under oath, but that they've represented to you from the federal government that this would have a negative consequence on your application. All right, anything else, Luke?
No, I think that summarizes it.
All right.
Our position, Judge. Thank you.
And when he first asked this, I said, well, I can't just wave my pen and make this go away. I said, you could use some legal help, and he got you to file an actual brief. The court rule that you cite, 6.435, is the one that has to do with correcting mistakes. Lord knows I've probably made my share of mistakes in court orders over the years, but there's a rule that lets you fix it. Prosecutor contends this isn't a mistake. It's what they intended. Ms. Stoll, what's your position here?
Your Honor, I seriously doubt that my use of the word plea in the nollie has any effect on the defendant's immigration.
Listen closely to what's happening here. The defendant isn't just worried about immigration status. His employment may also be on the line. Federal contractors often undergo extensive background checks, and unresolved legal matters can create serious complications. Even when charges are dismissed, the existence of an arrest or certain legal terminology can trigger additional scrutiny. That's why this hearing feels bigger than a dispute over wording. It's about whether the justice system can fully erase the effects of an accusation after a case has been dismissed. For many viewers, this raises a larger question. If the legal system agrees to dismiss a case, should collateral consequences continue to follow someone afterward? Let us know your thoughts in the comments.
The defendant's immigration status, if ICE is trying to get a hold of him, I would assume that it's because he was arrested for domestic assault on his wife. And that besides, the word plea is not synonymous with guilt. I define that from the Black's Law Dictionary in my brief. And I really don't think that the term or the phrase plea agreement should be given that much consideration. It's a generic phrase that's used and every day in our office. And I believe that also applies to cases where they're dismissed, not necessarily reduced.
I don't know as much of the facts as the prosecutor does. The prosecutor has the whole police report. I have an affidavit of probable cause that came with it, or a bond report. And they may not wish to give you any further relief. The police, Three Rivers Police, were dispatched to Three Rivers Hospital for a female that came in with a suspected assault.
The prosecutor's argument is straightforward. The phrase plea agreement is a common legal term and does not automatically imply guilt. In fact, legal terminology often has meanings that differ from how ordinary people interpret them. That's why the prosecutor references Black's Law Dictionary, the gold standard for legal definitions. From their perspective, nothing was inaccurate or mistaken. And that's crucial because the defense filed this under a rule designed to correct errors. If there was no error, then legally speaking, there may be nothing for the court to fix. This moment illustrates how much power language holds in the legal system. One side sees harmless wording. The other sees a threat to immigration status and livelihood. Same words, completely different consequences.
She was distraught and in an emotional state. She advised she was riding in the vehicle with her husband on US 131 near Broadway when he got upset and started to hit her with a closed fist in her arm. I could visually see redness and bruising started to form on her arm. She explained that it happened around 4:30 and the husband kept driving. When she got home, she jumped into the driver's seat, drove herself to the emergency room. She advised she thought her arm was broken. She sought immediate medical treatment from the assault. So that was what was used to set the bond. So you weren't acquitted. You didn't have a trial and were found not guilty. By the grace of the prosecutor, they asked you to do certain things and you agreed to do them. The matter was dismissed. That was part of a plea agreement. You pled not guilty. They agreed after that plea that if you met certain conditions, the case would be dismissed. If we take out plea, the word plea, defendant has been complied with all terms of the agreement. I don't know exactly what that means. It probably, as Abigail said, we use the word plea and plea agreement all the time. But when I moved from my old office to this office, I found about 3 copies of Black's Law Dictionary. And from time to time, we actually go back to it. Black's Law Dictionary defines the term plea as an accused person's formal response of guilty, not guilty, or no contest in a criminal charge. The word plea itself does not denote conviction or admission of guilt. And they contend that it is not an error. And they put the word in there intentionally. And it's their order. Now, it was without prejudice. I suppose we can withdraw the plea and go back to square one. But I don't think anybody wants to go down that road. So I appreciate your concerns. I don't know whether what somebody told you over the telephone is going to be cast in stone. But let's assume that you had entered into the prosecution's deferral agreement. There's a special statute, 750.
The judge now turns to legal definitions, and this is often where cases are won or lost. By citing Black's Law Dictionary, the court is grounding its decision in established legal meaning rather than emotional consequences. The judge points out that a plea doesn't necessarily mean guilt. It can include a not guilty plea as well. That's a critical distinction. However, immigration law doesn't always align perfectly with criminal law. Something considered routine in state court can sometimes carry unexpected federal implications. This hearing highlights a recurring issue in American law. Different systems often speak different legal languages. The question becomes whether state courts should adjust their records to account for those downstream consequences, or whether their role ends once the criminal case itself is resolved.
769A, I think it is, which allows the prosecutor to defer and dismiss a criminal case. I can't do a deferral in a domestic violence case without the prosecutor's consent. But if they consent and I put you on the probation and you agree to the terms of the probation and complete all the terms, the charge is removed from your record as a criminal record of conviction. It would have actually been a conviction, but it's pulled back out of the system, including the fingerprints stay, but the conviction becomes non-public. This was more than that. They absolutely dismissed the case altogether. You did some terms which would have been similar to an agreement for a deferral, and they agreed to dismiss it, meaning your fingerprints are returned, your DNA is returned, and the case is removed from the system. And their position is, that's as far as we're gonna go. We believe you punched your wife in the arm and she went to the hospital. And if this isn't good enough, I don't know what else to say. That's their position. And I'm not gonna correct a mistake that the prosecutor contends was not a mistake. They put the language in there on purpose. I signed it. I returned all your fingerprints, had the matter removed from the system. And hopefully that's enough. It is, if it isn't, there's a consequence to acts. And there's a very large consequence here. It's called a collateral consequence. It's outside.
This may be the turning point of the entire hearing. The judge acknowledges the defendant's concerns, but introduces a legal concept known as collateral consequences. These are consequences that exist outside the direct punishment of a criminal case. Things like immigration issues, professional licensing problems, or employment restrictions. Courts often recognize these hardships, but they don't always have the authority to fix them. That's why the judge's comments are so important. He appears sympathetic, yet constrained by the law. It's a reminder that even when someone avoids conviction, the effects of an arrest can linger for years. Do you think courts should have broader powers to prevent collateral consequences, or would that go beyond their role in the justice system?
It's outside the purview of the court. Well, anyway, I'll do an order denying your motion, and then you can say that, yes? I don't want to hear anything you have to say. You're not the party in this case. You're the complaining witness. They agreed to those terms and conditions, I think, after talking with you. You don't have standing to give any input in the nature of this dismissal. So, all right, I don't think everybody's happy with this, but that's my rule. And then I'll do an order indicating that the motion to alter the order was denied because it was not.
In the end, the judge denied the motion, concluding that the wording in the dismissal order was intentional and therefore not a mistake under the applicable court rule. The defendant's criminal case remains dismissed. His records were ordered removed as permitted by law, but the court declined to alter the phrase plea agreement. This case demonstrates how legal outcomes don't always end when a case is dismissed. Immigration consequences, employment concerns, and federal regulations can continue to impact someone's life long after a courtroom ruling. It also highlights the difficult balance judges face between following legal procedure and addressing real-world consequences. Whether you agree with the ruling or not, this hearing shows how a few words in an official document can carry enormous weight. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.